And he was arrested in, just remind us of the date.
It was the 26th of June. It would be AJ1, let me just be sure. It would have been the 26th of June, 2025, Chair.
26th of June, 2025. Okay. You didn't, in terms of protocol, take it upon yourself to inform the National Commissioner that one of his most senior officers was going to be arrested? Or did you follow some other protocol involved when a very senior person is involved?
Correct, Chair. The protocol I follow, since I report to and am accountable in terms of my reporting to the National Director of Public Prosecutions, I did inform the National Director that the Head of Crime Intelligence, Lieutenant General Khumalo, and others would be arrested. I do not discuss the merits of the matter with the National Director, but I did indicate that in terms of the Section 27 referral, we had worked out those matters within the ambit of the definition of state capture, but that there were individual matters that dealt across the board with fraud, corruption, and or defeating, and this matter would be enrolled. We did the same, Chair, when it was the first matter that was to be enrolled as well. So each time I inform the National Director that there's going to be a matter that appears on the roll, and that is for all matters. I do not discuss the merits of the matter because I have the discretion as the ID, as do directors of public prosecutions, to institute prosecutions for and on behalf of the state.
Did you inform the National Commissioner?
I did not. I informed the National Director.
Okay. Now, did you inform Lieutenant General Khumalo?
We didn't inform him. When he was to be apprehended, he was informed what he was being apprehended for, that IDEC was in possession of J50 warrants of arrest. We asked that, well, the investigators asked that he kindly accompany them. Lieutenant General Khumalo was not placed in cuffs because he was returning from a trip and he was at the airport. It's a public place. One didn't seek to embarrass him. One merely sought to secure his attendance. And in fact, we did that for all of the other accused. They were called and told to please hand themselves over at the Brooklyn police station. These were senior members of the police who had been in their office. If we thought there was a risk that they could flee, one would have acted differently. But at the time, we didn't have a reasonable belief that that would happen. So when he was approached, there was no obstruction from himself. He got into the vehicle with the two IDEC investigators, and at all relevant times of that trip, even till it ended at the Brooklyn police station, his entire security entourage followed and knew where he was at all times. We did afford him that respect. We wanted to secure his attendance in court. That was the bottom line. One could have executed the warrant. We had a valid warrant. That was not the purpose of the exercise. The exercise was a method of securing his attendance together with the co-accused, and we treated all of them the same. So we didn't execute warrants on some and not on others. We called and asked them to hand themselves over.
So it sounds to me that unless you knew that, firstly, this is Lieutenant General Khumalo at the airport, secondly, that he was being accompanied by other police officers and it appears to be some kind of an arrest, it wouldn't have been evident that he was being apprehended, arrested. There were no handcuffs, nothing like that.
Not at all. And I do recall that Lieutenant General Mkhwanazi indicated there was a dramatic arrest. There was no dramatic arrest. There were just two IDEC investigators. They approached him. spoke to him, and he went to the car. Even at the time of the conversations, his security detail was right there. So he never placed us in any danger. We didn't place him in any danger. We really secured the attendance of an accused in court.
A bit different from your Scorpions experience.
Honorable Chair, if one takes note of how IDEC has been operating, you will find that there hasn't been media coverage unless there was some rogue journalist who hid behind a bush that I'm not aware of, but we do not do media-style arrests. We apprehend our accused. They appear in court. Of course, once accused persons appear in court, everyone would know about it. But we sought in all of our matters to be as circumspect as we can be. If there's one lesson IDEC took from how the DSO operated and how not to operate, it was that, which is why I also was at pains to indicate, Honorable Chair, that mentioning people's names without having certainty about the criminal allegations and evidence against them would become highly irresponsible.
Subsequently, Lieutenant General Khumalo appeared in court. Yep, he would have applied for bail. Did you oppose bail?
In terms of the schedule of the offense, you had to read the bail opposition affidavits, but we had agreed to an amount of bail.
So would IDEC's own prosecutors be present in court and actually present the case
correct.
to the magistrate?
That is correct.
Okay. And would you, IDEC, have had anything to do with the bail conditions that were set by the presiding magistrate?
The investigator would depose to an affidavit. Prosecutor would read that out into the record and would ask for bail conditions. Yes, it's a prosecutor's job to deal with the bail application and bail conditions.
Now, you must please correct me if I've got it wrong, but the complaint seems to be that, or the effect of the bail conditions ultimately imposed was that Lieutenant General Khumalo and his co-accused would be prohibited from entering their offices, which effectively means that they couldn't do their job as crime intelligence officers. Just your comment on that, either if I got it right or wrong, or your comment.
The main interest we were weighing, at least the investigators and prosecutors, was the fact that several of our witnesses are from crime intelligence and in the employ of crime intelligence. And in the process of getting their statements, all had indicated that they had been victimized and was intimidated. What one sought to do, Honorable Chair, through the bail condition was prohibit the intimidation of witnesses. It had that unfortunate effect that the accused therefore could not return to their office. So we had to weigh the safety of the witnesses and the evidence that they would still have to give. So it wasn't per se directed at, we don't want you to do your work. It is the state's duty to protect their witnesses. And one of the conditions is, and we gave a list of names to the court, that these witnesses must not be contacted, etc., etc. That is normal. And part of the not going to the office was to ensure the safety of those. In fact, if you would allow me, Honorable Chair, in the one matter, the first matter, there was a time when General Lushaba went back to the office. And the witnesses were a flurry. We were inundated with calls about why were we, IDEC, so reckless about their lives that we didn't inform them. We were not aware he would go back to the office. It's not for me to comment on why he went to the office, but that was the effect of one person having gone to the office. So this is not a thumbsuck. It was the reality of witnesses who were in a very sensitive environment. And our duty is to the witness or witnesses.
So, as I understand or the reason for that particular bail condition was to protect the safety of witnesses, material witnesses in the matter, in the prosecution of Lieutenant General Khumalo and others, and that they were fearing for their safety or lives, and that would be the reason barring them from entering those offices where the witnesses were. And you have one instance where one of the accused had actually gone back to the office, and it caused some, let's call it, consternation amongst some of these witnesses.
Absolutely, Honourable Chair. And we all know that they're currently in court applying for an amendment of the bail conditions. Should the court find in the favour of the accused, IDEC is going to have to decide with the National Police Commissioner, what do we do about our witnesses who find themselves in that environment? That would still be a concern. We'd have to honour the court judgment, but we have to protect our witnesses. And that would be a conversation to be had. So if the court decides against us, we'd respect the finding, but it wouldn't take away the initial reason why the condition was set or requested.
Now, this is obviously based on media reports, so you can ignore it or reject it or respond. But did they go back today to seek an amendment to their bail conditions, and did it relate to this issue of access?
That is correct, Honourable Chair. The application for the bail amendment did start some time ago. I think it started in October. But given the Madlanga Commission and the fact that Lieutenant General Khumalo had to testify, etc., the matter moved itself along. And today was the first agreed to date for the court to continue to adjudicate. However, what also happened is, given the aspersions cast on the presiding officer who agreed to those conditions, the presiding officer decided, well, his name was being dragged through the mud, and so he would have to step down. And that caused, again, a disruption in terms of proceedings and process.
So did a new or newly appointed presiding officer, was he or she appointed today to hear the application for an amendment?
On the previous occasion, when the name of the presiding officer was made known at the Madlanga Commission of Inquiry, the presiding officer came into court, the original one, indicated that he would rather step down. He will also be applying to the commission to testify because of the aspersions cast on himself. There was an adjournment of the matter, and then another presiding officer was brought in to indicate that the matter is being postponed to today, and that today there would be a new presiding officer. However, the state applied for a motion application indicating that this would really waste time and is not in the interest of justice. This matter was already part heard, and that the original presiding officer who was dealing with the bail amendment should finish the matter. And that application was filed in the High Court. I'm not aware of what is happening in court at the moment. I'd be able to get feedback when we are done for the day to find out if a new presiding officer was in fact allowed to proceed, because it means everything starts from scratch, and that prejudices all the parties, state and defense included.
What consideration, if any, went into the fact that effectively our crime intelligence was now hamstrung by our top crime intelligence investigators being barred from office? They haven't been suspended from work, they haven't been dismissed, but because of a bail condition, they cannot perform their functions, which is so crucial to the criminal justice system.
What I can say, Honourable Chair and members, is they are not physically there, but they are still within the employ of SAPS. I have no doubt that they continue to work and or engage with colleagues, albeit not the witnesses that they were barred from engaging with. But crime intelligence is not hamstrung. There are acting persons that are carrying on with the job and have continued to do so, including a Major General who's acting as the Divisional Commissioner for Crime Intelligence. In all of those positions of the current accused, there are persons acting and the work continues. The National Commissioner himself has not indicated to IDAC that, unfortunately, crime intelligence, which is such a key component, cannot do its work. Rethink your stance. That has not happened.